5 seconds to go. Start. But according to the medical evidence, injuries on PW2 were caused on the evening previous to the morning of June 24. This takes away the basis on which he was accepted by the trial court and the High Court as an eyewitness, notwithstanding his proclivity to mix up falsehood with truth. A substantial part of the prosecution's story has been disbelieved, and the conviction of the appellant rests solely on the testimony of PW2, who, as observed by the trial court, does not seem to have particular respect for truth and had mixed up falsehood with truth. His credibility as an eyewitness lay only in that the trial court and the High Court assumed that he had received injuries in the same occurrence in which the deceased was killed. That assumption does not appear to be very sound and is not borne out by the evidences on record. The defense plea that PW2 had received the injuries on the evening of June 23 and not in the morning of June 24 gains credence from the fact that an incident between the two sides had admittedly taken place on the evening of June 23, 1995. In the face of this admitted position and the medical evidence, it is difficult to accept that the injuries found on the person of PW2 were received by him in the morning of June 24. From this, either of two inferences would logically follow. 1. PW2 was not present at the occurrence in which the deceased was killed in the morning. The occurrence in which the deceased was killed did not take place in the morning of June 24, and he was not killed in the manner as suggested by the prosecution. Both the inferences are equally damaging to the prosecution case. In view of the facts and the circumstances, it would be highly unsafe to uphold and sustain the appellant's conviction for the offense of murder, and the prudent and safe course would be to give him the benefit of doubt. Accordingly, he is acquitted of the charges under section 302 and 324 IPC. The next appeal is directed against the judgment of the Punjab and Haryana High Court in Criminal Appeals numbers 201 of 1996, confirming the appellant's conviction under section 302 of the Penal Code and life imprisonment. The appellant, along with 6 others, was prosecuted for commission of offences punishable under section 148 IPC. The appellant and other accused attacked D. 2 of the accused gave lathi blows on his back, and as he fell down, the appellant gave a knife blow on the left side of his chest. That accused R also gave knife blows to him. PW2 further stated that when he and his uncle tried to save D, accused R gave a knife blow on his left hand thumb, and 2 other accused gave him 5 lathi blows. His uncle was also stated to have received a lathi blow on his head. As to the cause of incident, PW2 stated that as his other brother PW6, who had been elected as village sarpanch, did not pay heed to unreasonable demands of accused persons, an altercation took place between both the sides the previous evening, but the matter was then patched up. The post-mortem examination of the body of D was conducted, and it indicates that one stab wound on the left side of the chest as the cause of death and the other injuries as post-mortem in nature. The trial court convicted and sentenced one appellant under section 302 and 324 IPC. Three other accused were convicted and sentenced under section 323 IPC. The remaining three were acquitted of all the charges. By a separate judgment, the appellant was also convicted under section 25 of the Arms Act and was sentenced to the period already undergone. The High Court upheld the judgments of the trial court. Aggrieved, the appellant filed criminal appeal challenging his conviction and sentence under section 302 and 324 IPC and criminal appeal number 132 of 2007 challenging the conviction under section 25 Arms Act. The trial court doubted the presence of PW4 and PW6 at the place of occurrence and did not accept their testimonies as eyewitnesses. According to the prosecution, the occurrence in which the deceased was killed took place shortly in the morning of June 24, 1995, when PW2 was medically examined with his companion, that is to say, within an hour. Stop.